The next case is Unquity House Corporation versus Milton Assessors. This case involves a nonprofit corporation which was recognized by the IRS as an exempt entity under Section 501c3 of the Internal Revenue Code. The taxpayer owns a single residential building consisting of 40 260 square foot studio apartments and 99 400 square foot one bedroom apartments, and multiple common areas including a library, lobby, dining area, communal sitting room, laundry, hair salon, resident operated convenience store, cafe, and commercial kitchen. The taxpayer claimed exemption under Chapter 59, Section 5, Clause 3rd, and filed a Form 3 ABC and the Form PC. Next. During fiscal year 2019, the taxpayer operated a rental assistance demonstration under the U.S. Department of Housing and Urban Development, which we refer to as HUD. Eligible residents were required to be over 62 years old and have a median an income no more than 50% of the average median income for the area. The ceiling in FY19 was $42,000 for one person and $47,400 for two people. HUD and others supplemented below market rents. In 2016, the taxpayer received $867,866 in rental income, but considerably more than that, $1,158,297 in subsidies from HUD and municipal housing authorities. Next. A security deposit is required of tenants, and rent can be changed at any time for certain reasons. Among others, a change in the lessor's rent schedule, a change in HUD's allowances for utility or services, change in income, number of residents, or other factors change. Changes are required by recertification or subsidy termination procedures. The Section 8 housing assistance contract is terminated, or if the residents fail to provide required information. Next. Termination of tenancy was provided for material non-compliance with the lease, including one substantial or multiple minor violations of the lease, failure to supply timely required information, non-payment of rent, or lessee's refusal to accept changes to the lease if the HUD subsidy ends. The services provided to tenants at the subject property included daily social or educational activities, food programs, and subsidized transportation. All residents have emergency alert cords, such that the live-in maintenance worker is immediately dispatched to a unit in case of emergency. Next. South Shore Elder Services evaluated resident needs and, if appropriate, provided responsive services. The Greater Boston Food Bank supplied provisions distributed to residents. Hebrew Senior Life provided some nursing services as a part of a grant. The lease authorizes the lessor's access to units without advance consent only in cases of emergency. Next. The taxpayer failed to show that its dominant mission was traditionally charitable or that it provided community benefits to the town of Milton. The provision of moderately priced housing to low-income persons was held not to be a charitable endeavor in Charles Bank Homes v. Boston. The charitable services at Unquity House were largely rendered by third parties. Next. The taxpayer failed to detail or substantiate charitable services provided to residents beyond those inherent in the relationship of landlord to tenant. The taxpayer failed to prove its presence in residents' units to perform charitable activities. The exemption claim was denied.